Riya has taken a screenshot of the fake account. It shows her photograph, her name, and the fraudulent payment link. The screenshot looks convincing. But when the case reaches court, 5 questions arrive with it. Where did this image come from? Does it show the whole conversation or only a selected frame? Has the file changed since it was captured? Can the account be connected to a person? And has the electronic record been produced in the form required by evidence law? A screenshot may be useful evidence. It may even become an important part of the case. But a visible image is not self-proving. Between an online incident and a courtroom finding lies an entire legal chain: jurisdiction, investigative authority, production, search, seizure, forensic preservation, certification, expert analysis, and proof. This is beyond bare act, where a digital record is tested, not merely displayed. When someone asks, "Is a screenshot admissible?" the question is too small. First, relevance. Does the record relate to a fact that the court must decide? Second, admissibility. Has it been produced through the route required for electronic evidence? Third, authenticity and integrity. Is this what it claims to be, and is there a reliable basis for saying that it has not been altered? Fourth, attribution. Who created, sent, controlled, or received the account or message? Fifth, weight. After considering the whole context, how strongly does the record support the disputed fact? These questions overlap, but they are not interchangeable. A certificate does not automatically prove authorship. A hash does not prove that a statement is true. A forensic report does not decide guilt. And marking a file as an exhibit does not necessarily answer every challenge to its reliability. Our method in this episode is therefore simple. Preserve first, collect lawfully, verify technically, produce correctly, and prove each disputed link. Digital investigation does not begin by seizing every device in sight. Begin with the exact evidence object. Riya's screenshot is one object. Her original phone is another. The platform's account registration and access records are different again. The university's server logs and the payment provider's records have their own custodians, timestamps, and retention risks. Then identify the lawful collection route. A person may voluntarily provide a record or device. A court or an officer in charge of a police station may require production under the applicable law. A court may issue a search warrant. An investigating officer may conduct a search where the statutory conditions for a warrantless investigative search are met. And Section 80 of the IT Act creates a narrower public place power for specified officers. These routes should not be collapsed into one word: seizure. The legal basis determines who may act, what may be obtained, where the action may occur, which reasons must be recorded, and which safeguards follow. Episode 2 explains Section 75 in full, so we need only one continuity point here. The IT Act may apply to conduct outside India, irrespective of nationality, when the act or conduct constituting an offence or contravention under the Act involves a computer system, or computer network located in India. That is a rule of statutory reach. It does not, by itself, give an Indian investigator immediate access to a server, witness, or provider located abroad. Cross-border evidence may require a provider's lawful disclosure process, preservation before deletion, a court process, reciprocal arrangements, or a formal letter of request route under the Bharatiya Sakshya Adhiniyam. The exact route depends on the country, the evidence, and the applicable arrangement. So keep 2 questions separate. Can Indian law apply to the alleged conduct? And how can the necessary evidence lawfully be obtained and brought before an Indian court? Section 75 helps answer the first. It does not make the second disappear. Section 78 of the Information Technology Act answers a specific rank question. An offence under the IT Act is to be investigated by a police officer not below the rank of inspector. The provision does not mean that every event involving a phone or website becomes an IT Act offence. The investigating agency must still identify the substantive offence and its ingredients. It also does not mean that Section 78 contains the whole investigation code. The IT Act operates with the General Criminal Procedure Framework. For investigations and proceedings commenced after the new criminal laws came into force on July 1st, 2024. That general framework is the Bharatiya Sakshya Adhiniyam, 2023. Pending matters saved by its repeal and savings clause continue under the former Code of Criminal Procedure. This date matters. A current explanation should not present the former code as though it still governs every new investigation. The disciplined sequence is: identify the alleged IT Act offence, confirm the investigating officer's statutory rank, then identify the BNSS power used for production, search, seizure, arrest or cross-border assistance. Section 94 of the BNSS expressly addresses digital material. When a court or an officer in charge of a police station considers production necessary or desirable for an investigation, inquiry, trial or other proceeding, it may require the person believed to possess or control the material to produce it. The section refers to a document, an electronic communication, a communication device likely to contain digital evidence, or another thing. A court issues a summons. The officer in charge of a police station uses a written order. The requirement may itself be in physical or electronic form. This route matters when the relevant custodian can identify and supply the record, for example, a university's specified logs or a payment provider's account record. Section 96 deals with search warrants. A court may issue one where it has reason to believe that a production request will not be honoured where the material is not known to be in any person's possession, or where a general search or inspection will serve the proceeding. A production order identifies what a custodian must supply. A search authorises entry and inspection within its legal limits. Neither should be described casually as interception, which Episode 7 explained is a different power. Section 80 of the IT Act is often quoted too broadly. It permits a police officer not below the rank of inspector, or another central or state government officer authorised by the central government, to enter a public place and search and arrest without warrant a person found there who is reasonably suspected of having committed, committing, or being about to commit an offence under the IT Act. The statutory explanation includes a public conveyance, hotel, shop, and another place intended for public use or accessible to the public. Notice the limits. The power is tied to a public place. It is tied to reasonable suspicion concerning an offence under the IT Act, and it is exercised by the officers identified in the provision. Section 80 should not be converted into a general statement that every police officer may search any private home, device or cloud account without legal process merely because a cyber allegation exists. Nor does possession of a phone automatically authorise unlimited examination of every unrelated file on it. The lawful basis, scope, necessity and handling of the particular search still require careful analysis. Section 185 of the BNSS permits an officer in charge of a police station or an investigating police officer to search within the relevant police station limits when there are reasonable grounds to believe that something necessary for an authorised investigation is located there and cannot otherwise be obtained without undue delay. The officer must record the grounds in the case diary and, so far as possible, specify the thing sought. The officer should conduct the search personally where practicable. If a subordinate is required to act, written reasons and a written order specifying the place and, so far as possible, the object are required. The search is not meant to be invisible. Section 105 requires the process of search and seizure, including preparation of the seizure list and the witnesses' signatures, to be recorded through audio-video electronic means, preferably a mobile phone. The recording must be forwarded without delay to the identified magistrate. Section 185 also requires the relevant records to reach the nearest competent magistrate within 48 hours. The owner or occupier may apply to the magistrate for a free copy. Section 106 separately permits in police seizure of property alleged or suspected to be stolen or found in circumstances creating suspicion of an offence, with prompt reporting obligations. These provisions do not resolve every digital search controversy, but they show why legality depends on a recorded route, not merely on the investigator's conclusion that evidence might be useful. Digital evidence can be unusually fragile. A post can be deleted, a cloud log can rotate, a device can synchronize, overwrite, or remotely erase data. A careless click can change a last access time. Disconnecting a running system may destroy volatile memory. Leaving it connected may permit remote alteration. That is why first response is not a universal instruction to switch everything off or to keep everything on. The correct action depends on the device, its state, encryption, network connection, safety, and the investigator's competence. For an ordinary complainant, the practical aim is preservation without risky self-investigation. Retain the original device where possible. Capture the full context rather than a cropped allegation. Note date, time, account identifier, and URL. Keep the original file. Avoid repeatedly forwarding or editing it, and report quickly enough that legally obtainable provider records are not lost. For investigators and organisations, trained personnel should document the scene, system state, network status, date and time source, people present, and every action taken. Relevant records should be collected through a lawful and forensically defensible process. Preservation is not proof, but poor preservation can make proof far harder. In forensic work, make a copy can mean very different things. An ordinary file copy may collect the visible file while changing metadata or omitting deleted material, unallocated space, and other device-level information. A forensic acquisition is designed to preserve the relevant data in a controlled manner. Depending on the device and legal authority, the examiner may create a bitstream image or use another validated acquisition method. A write blocker may be used where appropriate to prevent changes to the source media. The examiner records the tool, version, method, date, time, device identifiers, errors, and limitations. Analysis is normally performed on a verified working copy, not by experimenting repeatedly on the original. Mobile devices and cloud systems complicate the picture. Encryption, live data, application databases, provider-controlled content, and synchronized accounts may require methods different from imaging a removable drive. The legal lesson is not that one technical ritual fits every device. It is that the method must be documented, repeatable where possible, and appropriate to the evidence source. A cryptographic hash is a fixed-length value calculated from digital data. Use SHA 256 as our illustration. If the same file is hashed again without change, it should produce the same value. Alter even a small part of the file and the value should change. Matching hash values can therefore support the proposition that a collected file and a later examined copy are the same at the bit level. But do not ask a hash to prove what it cannot. A matching hash does not prove who created the file. It does not prove that the information inside it is true. It does not prove that the original source was lawfully accessed, and it does not reconstruct missing context. The schedule to Section 63 of the Bharatiya Sakshya Adhiniyam expressly contains fields for hash values and a hash report. It lists SHA1, SHA256, MD5, or another legally acceptable standard. For a modern explanatory example, SHA256 is the clearer choice. The statutory forms list should not be mistaken for a technical claim that every listed algorithm has equal contemporary strength. Think of a hash as an integrity check on identified data, not as a verdict. A chain of custody records the history of the evidence. What was collected? From where? By whom? At what date and time? In what condition? How was it identified, packaged, sealed, stored, transferred, imaged and examined? Who had access at each stage? Were the seal and hash values verified? The purpose is not paperwork for its own sake. The record allows the court and the opposing party to test whether the item examined is the item collected and whether an unexplained opportunity for alteration exists. A gap does not produce one automatic consequence in every case. Its significance depends on the evidence, the surrounding proof, and the challenge raised. But an unexplained gap can weaken confidence in integrity and weight. Digital evidence often exists in several legitimate versions: the original device, a forensic image, a verified working copy, an exported report, and a court exhibit. The chain should explain how each was derived from the previous one. The strongest account is chronological, specific, and reproducible. Section 79A of the IT Act allows the central government, by Gazette notification, to specify a central or state government department, body, or agency as an examiner of electronic evidence. The purpose is to provide expert opinion on electronic form evidence before a court or another authority. The statutory explanation is broad. Electronic form evidence includes information of probative value stored or transmitted electronically, including computer evidence, digital audio, digital video, cell phones, and digital fax machines. Section 39, subsection 2 of the Bharatiya Sakshya Adhiniyam makes the opinion of the Section 79A examiner relevant when the court must form an opinion about information transmitted or stored in a computer resource or another electronic or digital form. The examiner is treated as an expert. Relevant does not mean conclusive. An expert may explain acquisition, recovery, metadata, tool validation, hash comparison, signs of manipulation, and technical limitations. The court evaluates the opinion with the method, underlying material, other evidence, and cross-examination. A notification creates expert status for the statutory purpose. It does not transfer the court's decision to the laboratory. The current evidence statute is the Bharatiya Sakshya Adhiniyam 2023, in force from 1 July 2024. It expressly defines documents to include electronic and digital records. Its illustrations mention emails, server logs, computer and smartphone documents, messages, websites, location evidence, and stored voicemail messages. Section 61 says that an electronic or digital record cannot be denied admissibility merely because it is electronic or digital. Subject to Section 63, it has the same legal effect, validity, and enforceability as another document. Section 62 directs that the contents of electronic records may be proved in accordance with Section 63. The transition rule is equally important. If an application, trial, inquiry, investigation, proceeding, or appeal was already pending immediately before the BSA commenced, Section 170 saves the application of the former Indian Evidence Act to that matter, so a careful lawyer asks for the proceedings date before naming the governing evidence provision. For a new proceeding, use Sections 61 to 63 of the BSA. Do not mechanically cite Section 65B of the Repealed Evidence Act, as though the statutory text never changed. The distinction between an original electronic record and a computer output remains practically important, but digital originals are not always as simple as one physical sheet of paper. Section 57 of the BSA expands the illustrations and explanations of primary evidence. It recognises, for example, that where an electronic or digital record is created or stored across multiple files, each may be primary evidence. Simultaneously stored or transmitted video recordings may each be primary evidence. Automated storage, including temporary files, may also qualify in the circumstances described by the section. Section 63 addresses a computer output. Information printed, stored, recorded, or copied in the electronic forms described by the provision and produced by a computer or communication device. If the statutory conditions are satisfied, that output is treated as a document and may be admitted without producing the original device. This matters because a social media record may live on a provider's distributed system. A CCTV export may come from a DVR, a call record may come from a telecom server, and a message may be presented from a phone or as an exported file. The lawyer must identify what is actually being tendered and how it was produced. Calling every file the original or every screenshot secondary evidence without examining the source can obscure the real statutory analysis. Section 63 sets out the route for a computer output. In simplified terms, the device or system must have been regularly used for the relevant activity by a person with lawful control. Information of the kind in question must have been regularly fed into it in the ordinary course. The system must have operated properly, or any malfunction must not have affected the record or its accuracy, and the output must reproduce or derive from information supplied in the ordinary course. Modern systems may involve several computers, networks, resources, and intermediaries. Subsection 3 tells us when they are to be treated as one computer or communication device for this purpose. Subsection 4 requires a certificate to accompany the electronic record at each instance when it is submitted for admission under the section. The certificate identifies the record, describes how it was produced, gives appropriate device particulars, and addresses the statutory conditions. On the text of the provision, it is signed by the person in charge of the computer or communication device, or the management of the relevant activities, and an expert. The schedule supplies two parts. Part A for the party and Part B for the expert. It asks for the device or digital record source, identifying details, hash value, algorithm, date, time and place, with the hash report enclosed. This is not the old Section 65B certificate copied under a new heading. The current form and wording must be read directly. Two Supreme Court decisions remain essential background, but their statutory setting must be stated accurately. Anvar P. Veig versus P. K. Bashir, decided in 2014, held that secondary electronic evidence under the former Evidence Act had to satisfy its special electronic evidence provision. The general route for secondary documentary evidence could not be used to bypass Section 65B. Arjun Panditrao Kotkar versus Kailash Kushanrao Gorantyal, decided by 3 judges in 2020, reaffirmed that the Section 65B certificate was a condition precedent for a secondary electronic record. It clarified that the certificate was unnecessary when the original electronic record itself was produced by the owner or operator of the device who proved it. It also explained that a party unable to obtain a certificate from the person controlling the system could seek the court's assistance. Those holdings interpreted the Indian Evidence Act 1872. They remain important for proceedings saved under that Act, and for understanding why Indian law insists on a reliable production route. But for a new proceeding governed by the BSA, the current analysis must begin with Section 63 and its schedule, including the textual changes. The cases illuminate the problem. They do not authorise us to ignore Parliament's new wording. Return to the screenshot. A proper Section 63 route may address the legal production of the computer output. That does not automatically prove that the account belonged to the accused, that the screenshot is complete, or that every statement in it is true. Attribution may depend on several pieces of evidence: account registration and recovery details, access logs, device artifacts, IP and network records, treated with their limitations, payment destinations, possession and control, witness testimony, and the consistency of timestamps and surrounding messages. Even then, avoid one-to-one assumptions. An IP address may identify a connection, not necessarily the individual who used it. A device may be shared, an account may be compromised, a display name may be fabricated, metadata may be changed or stripped, a cropped screenshot may conceal what came before or after. The court therefore asks whether the whole body of evidence supports the claimed origin, integrity, and meaning. Certification addresses an evidentiary route. Forensic examination addresses technical questions. Corroboration addresses factual inference. None should be used as a substitute for the others. Now apply the complete method without inventing facts. Riya preserves the full screen context, original screenshot file, account identifier, URL and time. Her phone remains available as a possible original source. She does not edit the image or rely only on a forwarded copy. Investigators identify the alleged offences and confirm the Section 78 rank requirement. They separate voluntary material from records requiring a Section 94 production order, a judicial warrant or another lawful search power. If Section 80 is invoked, they test the officer, the public place, the reasonable suspicion and the IT Act offence. If Section 185 is used, they record the grounds, specify the object, and follow the audio-video and magistrate safeguards. The university logs, platform records, and payment evidence are preserved before routine deletion. Each source is collected with identifiers, dates, custodians, and a documented chain. The original device or acquired data is protected. A validated method creates the examination copy. Hash values are recorded and checked. The examiner states any limitation, rather than implying certainty, the method cannot provide. In court, the party identifies whether the BSA or the saved former act applies. For a computer output under the BSA, the Section 63 conditions and current schedule are addressed. Finally, the prosecution or claimant proves the disputed links: integrity, context, account control, authorship, conduct, and the ingredients of the substantive offence. The screenshot is no longer treated as a magic answer. It becomes one properly tested part of a larger evidentiary chain. For an exam problem, advisory note, or real investigation, use this 12-question method. 1. What exact electronic record or device is relevant? 2. Which fact is it offered to prove? 3. Which substantive offence or contravention is alleged? 4. Does Section 75 matter, and what Indian computer connection is proved? 5. Who is legally authorised to investigate? 6. Was the material volunteered, produced, searched for, seized or intercepted, and under which power? 7. Were reasons, scope, recording and magistrate safeguards followed? 8. How was volatile evidence preserved? 9. How were the original forensic copy, hash and chain of custody documented? 10. Which evidence statute applies on the proceedings date? 11. If Section 63 applies, are its conditions and current certificates satisfied? 12. What independent evidence proves authenticity, context, and attribution? Answer those questions in order, and can a screenshot prove it becomes a legal analysis rather than a guess. Digital evidence is not weak merely because it is digital, and it is not reliable merely because it appears on a screen. Section 78 identifies the rank for investigating IT Act offences. Section 80 creates a confined public place power. The BNSS separates production, warrant, search and seizure, and places recorded safeguards around investigative action. Section 79A and Section 39 of the BSA provide a route for expert electronic evidence opinion. Sections 61 to 63 recognise electronic records while requiring the current proof structure for a computer output. The rule to remember is this: trust is built link by link, from source to collection to integrity to production to attribution. In Episode 9, we move from proving the record to securing the system, protected systems, critical information infrastructure, NCIIPC, and the legal architecture of national cybersecurity. If this episode clarified the law, subscribe to Beyond Bare Act. Here, we do not ask only whether a file exists. We ask whether the legal chain can support it.